I will go ahead and call the first case on our docket today, People versus Robert Propp. You each have 20 minutes. Mr. Helton, I'll let you go for a little bit and then interrupt you. And we will question you justice by justice in a little more organized way than we do in the courtroom, but no guarantees that it'll be especially organized. So if you are prepared to proceed, please do, Mr. Helton.
Absolutely, and please feel free to cut me off whenever. Stephen Helton of the State Appellate Defender Office on behalf of Robert Propp. I'll keep track of my own time and do my best to save a few minutes for rebuttal. The reasons the Court of Appeals gave for concluding that Mr. Propp's due process right to an expert weren't violated by the trial court were identical to the reasons provided by the Oklahoma Attorney General in Ake for why the United States Supreme Court should find that Ake's due process rights to an expert weren't violated. The Ake court rejected those arguments because adopting them would have deprived indigent defendants of the tools necessary to present their defense. And this court should reject the Court of Appeal majority's opinion for the same reason. The court should also reject the Court of Appeals interpretation of MCL 76827B as prohibiting evidence offered under the statute from being excluded based on common sense evidentiary rules, like the rule prohibiting hearsay from being admitted and considered for its truth when it lacks any indicia of reliability. There's no reason to believe the legislature intended the statute to have this radical effect. Several reasons to conclude that it did not, and no question that the trial court's interpretation of the statute in this manner undermined the reliability of Mr. Propp's verdict. I'm happy to answer any questions if the court has any, or to continue.
Thank you, Mr. Helton. Let me turn justice to justice for those questions. Justice Zahra, I'll start with you.
Not at this time, but thank you very much.
Justice Viviano.
No questions, thank you.
Justice Bernstein.
Hey, good morning. Just a question. Tell me about the elements here and, just the standard of proof that's, we're looking at. And, if you could expand on the burden shifting.
In terms of the Kennedy analysis.
Yes.
So from Kennedy, the court was pretty clear what a defendant who is looking for state funds to retain an expert has to do is they have to inform the court of the nature of the prosecution's case and the evidence against their client, explain to the trial court why the defense expert is necessary, and how the defense hopes to use that to use the expert to prepare for the defense, and that's basically it in terms of what the trial attorney needs to say when he's requesting an expert. He's entitled to an expert when he can show that the expert will assist the defense and that the trial will be where there's a reasonable probability that the trial will be fundamentally unfair without an expert. That standard
and I guess the reason I'm asking that question is, does this case kind of present anything unusual as it pertains to what this expert's going to testify to?
Well, I would say, it is not the most common type of expert that we have, but it's similar to the types of experts described in cases like Kowalski, an expert in false confessions, or an expert in delayed disclosure in sexual abuse cases, where this is the type of expert who will come in and explain to the jury, human behavior that doesn't necessarily make sense inherently, or seems somewhat contradictory. So, in a false confession case, it's this person said that they committed this crime that they didn't really commit because of these factors. And in this case, I think the defense was asking for an expert who could come in and tell the jury, no, the people engage in this activity not because they're trying to harm each other, not because they're necessarily trying to engage in self-harm, but it does happen, and people do engage in this risk, and it is risky. And here are here's some of the fallouts, and I think that would have worked in this case, not only to provide a basis for the jury to understand Mr. Propp's testimony, but also to reject the state's introduction of testimony from the decedent's other boyfriends who testified, no, we never engaged in this behavior, because one of those witnesses was a boyfriend in high school, and the other said that they had just briefly been in a relationship. And so the expert would have said that people in long-term relationships, or why people might begin doing this practice later on.
Okay, thank you, counsel.
Justice Clement?
Good morning. I'd like to turn to what type of error we're talking about. And as you know, we found very few errors to be structural. We can list them. It seems like this might be an expansion to say that this would be a structural error. Can you talk about that? And then my second part of that is, if it's not structural and it's harmless, we have to look at it as harmless error. Tell me why this is not harmless in your opinion.
Yeah, absolutely. And I'll just answer the first question because I think it's pretty. I mean, the second question first, because I think it's a quicker answer. And this was harmful because the state brought in an expert who testified it's not possible that this could have occurred accidentally. If people are engaged in this behavior and someone passes out, then the other person's going to let up and death won't result. I know in our reply brief we cited a lot of academic journals that kind of go against this and would have pushed back on this. So that's the main thing. Is the main question here, I think everyone acknowledges, was intent. And the state's expert testified that this had to be intentional. And the expert the defense was requesting and was denied would have said, no, this is possible, and this is why it happens. And it would have also pushed back against the prosecution's witnesses about the decedent's sex life. As to whether or not this is structural or subject to harmless error, I know that the court was kind of struggling with how harmless error would work in this situation during the argument in Kennedy, and that's because the structural error error analysis is kind of baked in to the Kennedy standard, in that at the time the error occurs, the defendant's already established that there's a reasonable probability that the denial of this expert will result in a fundamentally unfair trial. And so to go back and say, well, even though at the time the trial was fundamentally unfair, it's still harmless, I think is inherently counterintuitive. Not to mention that the burden would be on the prosecution, and that would to demonstrate harmlessness, and that would essentially require the prosecution to go and demonstrate how the defense would have utilized this expert, how this expert would have, what kind of evidence this expert would have admitted at trial, and how the prosecution would have responded to it. I think there are too many variables, and I think the 11th Circuit, which created the Moore versus Kemp standard that Kennedy adopted, they recently held that at least in some circumstances this type of error is structural, because it cannot be quantitatively assessed in the context of evidence presented. Similarly, Texas also has this standard because, as they've said, we can conceive of few errors more structural in nature than one which eliminates the basic tools of an adequate defense. And so I think, this is sort of the same analysis as why can't a violation of the Sixth Amendment right to counsel be harmless? And it's because this goes to, the tools necessary to present a defense. And so withholding those tools, I don't think can be harmless.
Thank you.
Justice Cavanagh?
No questions for me right now.
Justice Welch?
Thank you. So, Mr. Helton, one of the issues raised by the prosecution in this case is the concern about everybody will be, able to qualify for an expert and sort of flood the system with expert requests. Using the Kennedy standard, how do you respond to that concern?
Yeah, absolutely. I think that I think that is I don't think there's anything to that concern. I've been an appellate attorney for quite some time, and I've seen two cases where a defendant has requested an expert, and the request has been denied. And both of those cases came from retained attorneys. One is this, and the other is being litigated. I don't think you would see experts being granted on demand for the same reason you don't see defense attorneys making frivolous requests to subpoena witnesses under MCL 775.15. They're not going to waste their own time filing these motions and then getting this expert that they have to do something with if they don't really think that they need it, and if they don't really think it's going to help their client. And not only is it going to create additional work for them, but it's going to probably sully their relationship with the judge if they make these requests and then don't actually use them. So I don't see that happening. We on appeal, we give trial attorneys so much deference in terms of how to tailor their strategy of defense and how to proceed, what evidence to present. And so when a defense attorney, especially in an open murder case, comes to court and tells the judge, this is what my client says happened, and I need this expert to be able to effectively present this defense to the jury because it's not going to understand it otherwise. I think trial courts have to defer to that because otherwise it's going to impact the defendant's Sixth Amendment right to present his defense at trial due to his poverty. So I think the court could deal with it if it sees people making frivolous requests, but this wasn't a frivolous request. This was a request for a single expert.
Thank you.
Mr. Helton, you have a bit of time left. You may continue or you may reserve.
I'll reserve. Thank you.
Okay, thank you. Mr. White, you may proceed.
Good morning, and may it please the court. Paul White on behalf of the people. Your Honors, we would ask that this court affirm the Court of Appeals decision on both issues. First, that this court should uphold the Court of Appeals determination that the trial court's denial of state funds for a proposed erotic asphyxiation expert did not violate this court's previous holding in Kennedy and did not violate appellant's due process rights. There was not a reasonable probability that the proposed expert would assist the defense, and even if the expert would have assisted the defense, there was not a reasonable probability that its exclusion created a fundamentally unfair trial. Second, this court should hold that evidence of other acts of domestic violence is admissible under MCL 768-27B, regardless of whether it may be inadmissible as hearsay. 768-27B is a substantive rule, a policy choice from the legislature that recognizes the longstanding problem of domestic violence in Michigan. It does not interfere with this court's ability to make procedural rules to govern the judicial system. It instead offers another tool for prosecutors to help break the cycle of domestic violence and seek justice for victims of domestic violence, not all of whom survive their abusers. This time, that's my opening. If anyone has any specific questions.
Thank you, Mr. White. Justice Zahra.
With regard to the second issue, wouldn't the legislature have expressly permitted hearsay evidence in this context if it intended to do so?
Your Honor, I will concede that this is not, frankly, the A, the B, and the C statutes under this. They're all similar. None of them were, I would say, artfully drafted. I think that this is somewhat on the legislature, but I don't believe, and it sort of goes back to, inartful drafting is a problem here, but I will say that I believe that they intended to make 403 the sole limiting factor to take into consideration, Your Honor.
So let's take the Watkins case into consideration. What's the most meaningful difference between Watkins that would lead us to infer that the legislature's silence that would suggest that it intended to create a conflict between the statute and the rule of evidence?
Well, Your Honor, the Watkins case did look at 27A, not 27B. And you're right, it did say that it's subject to the evidentiary rules. However, even though that rule is not specifically incorporated into the statute, and again, this is somewhat, I think, going back to the legislature having, whoever drafted these did not do a very a good job, but in making B subject to 403 as the sole limiting factor here versus 27A requires a broader look at other evidentiary rules. I hope that answers your question.
Okay, thank you.
Justice Viviano,
No questions. Thank you.
Justice Bernstein,
And no questions. Thank you.
Justice Clement,
No questions.
Justice Cavanagh.
Can you answer the question? Is an accident an affirmative defense for requiring sort of a heightened standard as opposed to the prosecution's burden to establish intent? And if it is not, and it's part of the prosecution's burden, why wasn't the Court of Appeals in error in basing their analysis on that?
Mm-hmm. Your Honor, this is a good question. Our brief lays out why accident could be an affirmative defense in here, and I understand that the defense has a different perspective on whether or not it is an affirmative defense. It's our position that yes, it could be an affirmative defense to homicide, but there's no record really in the trial court for accident, other than this, when this motion was filed 1 month before trial. And in the previous 18 months, there had been no, this came up for the first time really a month before trial after several versions of a different story in terms of how the victim died in this case, Your Honor. So.
Okay, thank you.
Justice Welch.
I guess I'll piggyback a little bit on Justice Cavanagh. It seems like there's this catch-22 that a defendant's in. If they need the expert to prove their defense, at what point does the defendant get through the filter to qualify for an expert? Sure.
Well, and again, we're not saying that there is no possibility that the proposed expert could have assisted the defendant. And in a lot of situations, an expert may always have some sort of assistance, but we're not talking about mere possibility of assistance. We're talking about a reasonable probability of assistance. And unlike Kennedy, where we're discussing very technical scientific issues related to DNA, an expert who just discusses why people may engage in erotic asphyxiation does not, there's something different about that. And Mr. Propp was able to really discuss, I think, just as well at trial in terms of what erotic asphyxiation was versus what the proposed expert would have been able to do. The expert could not do a lot of things. He couldn't offer an opinion as to whether the victim died of erotic asphyxiation. He couldn't offer an opinion as to the intent of Mr. Propp. He couldn't offer an opinion as to whether the victim actually consented to being choked in this case. So I think there's two parts here. Kennedy seems to be really focusing on where the scientific or there's something very technical that an expert could assist on, which doesn't appear to be the situation here. And again, while an expert in this case may have been able to assist the defendant, that's certainly possible. We don't believe it reaches the level of a reasonable probability. And even if it does, it's a harmless, we would believe that this is a harmless error based on the overwhelming evidence against the defendant here.
Thank you.
Mr. White, I feel like we're pulling you through the same thing over and over again, so I apologize, but I feel like I hear you saying a few different things, which actually makes a lot of sense, but you started with accident can be an affirmative defense, and assuming we don't agree with you about that because the doctrine doesn't support it and treatises don't support it, but you also said sort of plan B, the defendant has not made out any facts to support the defense of accident, or that was what he was hoping to prove. But I think Justice Welch's point is sort of a serious one. It can't be heads I win, tails you lose. You can't have your expert, and therefore you didn't prove that you needed your expert, right? That feels a little bit fundamentally unfair. And so your final argument, though, that it wouldn't have made a difference, seems to be where you focused most of your time today. Is that your main argument to us, or do you want to rehabilitate A or B? I don't want to choose for you. I want you to choose.
The accident part I'll leave alone for the moment. In terms of the second part, I don't want to just focus on it being a harmless error, because I don't think that is that I'm not trying to make that the main portion of my argument. And again, I believe it comes down to Kennedy essentially establishes this threshold argument, and for establishing entitlement to an expert or expert funds, and frankly, I just don't believe that the trial court erred in believing that he didn't reach that threshold. So really, that's what I'd like to focus on the most, and I hope that answered your question.
Yeah, that's helpful. Thank you. I appreciate that. You have about 10 minutes left. Let me see if anybody has any further questions after those last questions. Anybody with additional questions for Mr. White? Okay, you may use your time if you wish. Up to you.
I will see the rest of my time. Thank you.
Thank you, Mr. White. Mr. Helton, you have some rebuttal.
Thank you very much. Regarding the proper interpretation of 76827B, to uphold the Court of Appeal majority's interpretation of that statute, the court would have to conclude that the legislature has the authority to prohibit trial courts from applying any rules of evidence at felony trials to certain types of evidence presented against certain types of clients. Defendants, and prevent this court from adopting rules that are applicable in total. So, I mean, they have specifically referenced 403 and incorporated that. But essentially, the Court of Appeals opinion says, prosecution can present privileged testimony.
Mr. Helton, if I can interrupt, this is the second or the third times you made specific reference to the Court of Appeals majority. There was no dissent, there was a concurrence. So, I'm very interested in Judge Murray's concurrence. If I were to agree that the Court of Appeals was wrong in its analysis of 27B as it relates to the rules of evidence, why wouldn't I be persuaded by Judge Murray's concurrence that the evidence otherwise properly admitted was more than adequate for the jury to convict the defendant? Defendant's statements to the police, defendant's testimony at trial regarding what he claims he did that led to the victim's death, and the testimony from the expert. Why wouldn't I be persuaded if I agree? If you persuade me that the Court of Appeals majority got it wrong, why would we reject the theory presented in the concurrence by Judge Murray, Chief Judge Murray?
Well, I generally agree that Judge Murray correctly interpreted the statute. But I think, our quarrel with him, with his opinion, is that he applied an incorrect harmless error standard. Harm isn't whether or not there's sufficient evidence to convict, eliminating the erroneously admitted evidence. And harm is not just an acquittal or a conviction. Mr. Propp was charged with open murder. The jury had to find he premeditated Ms. Thornton's death to find him guilty of first-degree murder, and there was not overwhelming evidence of premeditation in this case. And the strongest evidence of premeditation came from hearsay testimony from witnesses who lacked personal knowledge, who testified, I was told Robert strangled me till I saw stars and said, see how easily I could end this. That's extremely prejudicial. He was not able to confront that testimony, cross-examine it, and there's no evidence to corroborate that he engaged in this type of conduct, contemporaneously, other than through these hearsay statements. Likewise, with his ex-wife, who testified that she heard a banging on her window after they had divorced, and then police came and told her that they found Mr. Propp with a knife a block away from her house. This is the only information that came in that Mr. Propp, it's the only evidence that came in that Mr. Propp was in any way physically abusive or physically threatening to Ms. Thornton. And so I think that aspect of it is incredibly harmful. So I would leave it at that, other than to just say open murder, it's not just an acquittal or a conviction, and this was the strongest evidence that the state offered.
Thank you.
Sure.
I don't see any additional questions, Mr. Helton, but you have some time.
Okay. And I guess the just moving on, even if the court did conclude that the legislature could exclude the application of the rules of evidence in total, even if they could, that's defendants still have a due process right to a fundamentally unfair trial, and hearsay type of rules, those protect those rights, and we've cited a number of cases in that regard. And I'd cite another one that I saw today, Bridges versus Wixon, a United States Supreme Court case from 1945. The hearsay rules are, quote, designed as safeguards against essentially unfair procedures. To allow men to be convicted on unsworn testimony of witnesses is a practice which runs counter to notions of fairness on which the legal system is founded. And that I think that's true. I think, hearsay is the general prohibition of hearsay is wrapped up in the right to a fundamentally unfair trial. Regarding whether or not whether there's a reasonable probability that an expert would assist the defense, to show how necessary this expert was, the defense thought this expert was, trial counsel asked the state's expert to try to explain the practice, not knowing how he would testify. And that was, apparently a calculated risk that backfired severely on the defense. But this wasn't just, throwing it out there, a frivolous request. He counsel truly determined that this evidence needed to be presented to the jury. And, as with delayed disclosure type of cases where expert testimony is presented in order to explain to the jury why this type of activity that doesn't make sense happens, of course, the witness in those cases can say, I was abused at this point, I waited this long to come forward, as Mr. Propp did here with erotic asphyxiation, but that doesn't prevent the need for the jury to hear this from an expert about why this happens, which Mr. Propp wasn't able to do. And the standard for an expert is whether or not it will assist the jury in making factual determinations. And this expert would have, and it was fundamentally unfair to deny him the ability to present that information to a jury through his expert because of his poverty and because of the trial court's understanding of his due process right to an expert. So we'd ask the court to reverse both holdings of the Court of Appeals and remand and grant Mr. Propp a new trial. Thank you.
Thank you, Mr. Helton and Mr. White. The case will be submitted.
Thank you.